In the Court of Appeal of Alberta. Citation, Quaye v. Law Society of Alberta, 2021 APCA 167 date, 20210510 docket, 2003-0039 AC Registry, Edmonton. Between Gerald Quaye appellant, applicant, and Law Society of Alberta, Attorney General of Alberta and the College of Physicians and Surgeons of Alberta respondents. Underscore 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 on the court. The Honorable Madam Justice Sheila Grekel, the Honorable Madam Justice Don Pentelekik, the Honorable Mr. Justice Kevin P. and underscore 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 on. Memorandum of Judgment. Appeal from the order by the Honorable Associate Chief Justice J.D. Rook dated and filed the 20th day of January, 2020, ABQB 55, docket, 1903-21485. Underscore 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 on. Memorandum of Judgment. Underscore 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 on. The Court. 1. Gerald Quaye appeals a Court of Queen's Bench decision striking out his originating application pursuant to Rule 3.68 of the Alberta Rules of Court, Alterate 124/2010. The respondents to the originating application, and on this appeal, the Law Society of Alberta, the Law Society, the Attorney General of Alberta, the Attorney General, and the College of Physicians and Surgeons of Alberta, the College, invoke the vexatious application/proceeding procedure in Queen's Bench Civil Practice Note No. 7, the CPN 7. The decision to strike the originating application was rendered by A.C.J. Rook following the steps in the vexatious litigation. 1. Gerald Quaye, the Court. 1. Gerald Quaye appeals a Court of Queen's Bench decision striking out his originating application pursuant to Rule 3.68 of the Alberta Rules of Court, Alterate 124/2010. The respondents to the originating application, and on this appeal, the Law Society of Alberta, the Law Society, the Attorney General of Alberta, the Attorney General, and the College of Physicians and Surgeons of Alberta, the College, invoke the vexatious application/proceeding procedure in Queen's Bench Civil Practice Note No. 7, the CPN 7. The decision to strike the originating application was rendered by A.C.J. Rook following the steps in the vexatious litigation process, Quaye v. Law Society of Alberta, 2020 ABQB 55 Key No. 2. 2. This story begins many years ago when Mr. Quaye's father was a practicing physician in Fort Vermilion, Alberta. Dr. Quaye was involved in proceedings before the college, the upshot of which was that the college requested Dr. Quaye take certain measures to upgrade his skill level. He apparently chose not to do so. The case ended in 2000, when this court dismissed Dr. Quaye's appeal, expressing empathy for his situation and assuring him that the penalty imposed by the Expert Professional Standards Panel was largely rehabilitative, not punitive. Quaye v. College of Physicians and Surgeons of Alberta, 2000 APCA 38. Ultimately, in 2006, the college struck Dr. Quaye from the college register. In 2013, Dr. Quaye passed away. 3. What has transpired since, as explained by Mr. Quaye, is the understandable effort by his son to vindicate his father, and to vindicate himself, since in Mr. Quaye's view the decision to strike his originating application as frivolous and vexatious compounds the harm to his family's reputation in the community. 4. We turn to the events leading to this appeal. In 2015, Mr. Quaye swore a private information to commence a private prosecution against the college as well as the registrar in place at the time of the events involving his father. The Chief Crown Prosecutor stayed the proceedings, advising Mr. Quaye by letter of November 21, 2016. Mr. Quaye took two steps in response. He filed an application for judicial review of the stay entered in relation to the private prosecution, and 2. He filed a complaint against the Chief Crown Prosecutor with the Law Society. The application to judicially review the decision to stay the private prosecution. 5. On April 4, 2018, Nielsen J., as he then was, dismissed the application for judicial review of the decision by the Chief Crown Prosecutor to stay the private prosecution, and also the accompanying application for production of the exhibits filed in that matter. Neither dismissal decision was appealed by Mr. Quaye. See the chronology set out in Quaye v. Law Society of Alberta, 2019 AVQB 916 at paras 5-8 Quaye number 1. Page 2. 2. The complaint to the Law Society against the Chief Crown Prosecutor. 6. On February 6, 2019, the Law Society dismissed Mr. Quaye's complaint against the Chief Crown Prosecutor. Mr. Quaye appealed. On April 15, 2019, the Law Society of Alberta Appeal Committee dismissed that appeal. 7. Mr. Quaye then filed an originating application seeking judicial review of the Appeal Committee decision, alleging a breach of S15 of the Charter. No facts were set out or particulars given, though the originating application sought many remedies: certiorari, injunction, indictment, declaration, expedited trial, and damages. As noted, Mr. Quaye named as respondents the Law Society, the Attorney General, and the College. However, the document provided no indication which respondent was said to have breached the Charter or on what basis. 8. The three respondents wrote to the court, invoking CPN 7, a document-based review process designed to determine whether pleadings raise an apparently vexatious application or proceeding. They asked that the application be struck on numerous grounds, including that it was out of time, failed to plead a basis for the claim, and was otherwise improper and an abuse of process. The respondents further requested that two related applications brought by Mr. Quaye be stayed, for the production of documents sought in the prior judicial review action, and 2. That the Chief Crown Prosecutor be held in contempt for failing to comply with the notice to obtain record of proceedings in the prior judicial review action. 9. The court held that the originating application was suitable for review under CPN 7 and stayed the action, including the related applications, pending a final decision under the CPN 7 process, Quaye number 1 at paras 29, 37. 10. Having reviewed the written submissions of the parties, the court struck out the originating application and two related applications under Rule 3.68, Quaye number 2 at paras 17. First and foremost, it concluded the originating application failed to provide any basis for judicial review of the Appeal Committee decision or set out a factual foundation for a claim of breach of Section 15 of the Charter, para A. The court further held that the damages claim was improper, hopeless, and constitutes an abuse of process, para 10, and that the other relief sought was impossible, improper, bound to fail, or inadequately detailed, para 11. Finally, the court held that Mr. Quaye failed to address the court's concern that his application for judicial review was out of time and that he lacked standing to bring the judicial review at all, paras 12 to 13. 11. Mr. Quaye raises two grounds of appeal, alleging the decision below erred in failing to recognize that the respondent's invocation of CPN 7 was itself abusive, and 2. Not considering the alleged S15 breach of the Charter. On this latter point, Mr. Quaye suggests the court should have considered the evidence of discrimination filed as part of his CPN 7 response. Mr. Quaye has accordingly provided this court with voluminous documentation in his extracts of key evidence. Page 3. And, further, brought an application for admission of new evidence filed concurrently with his originating application and as part of his CPN 7 response. 12. We find, despite Mr. Quaye's compendious and sincere efforts, that he has failed to identify any reviewable error in the decision under appeal. There was nothing improper about the respondents seeking to avail themselves of the process under CPN 7, in light of the originating application filed in this case and given their articulated concerns that Mr. Quaye was collaterally attacking prior decisions. Nor did the court below err in declining to consider evidence relating to the S15 charter claim. 13. A central issue was whether the originating application failed to set out a reasonable claim such that it could be struck under Rule 3.68. 2b. On this question no evidence is permitted, Rule 3.68. 3. This is because a motion to strike is not about evidence, but the pleadings. RB Imperial Tobacco Canada Limited, 2011 SCC 42 at par 23, 2011 3 SCR 45 Imperial Tobacco. A claimant must plead material facts sufficient to make out its claim. Imperial Tobacco at par 22, Ruby v. Mills, 2019 ABQB 451 at par 35, Application to Restore Appeal dismissed 2020 APCA 223, Mancuso v. Canada, National Health and Welfare, 2015 FCA 227 at par 16 Mancuso. This requirement applies equally to the Charter, Mancuso at par 21. 14. Mr. Quaye failed to set out any facts in his originating application. That was the defect addressed by the court below, not whether Mr. Quaye was capable of providing sufficient evidence regarding a breach of S15 of the Charter. The latter issue was not before the court below, nor is it before us. Accordingly, Mr. Quaye's new evidence is no more relevant to this appeal than the other evidence upon which he relies. 15. While we find no reviewable error in the decision under appeal, we wish to acknowledge that Mr. Quaye fully explained the basis of his S15 charter claim. His materials and oral submissions were based on his view that the college breached the charter by maintaining his father on a special register, and on his view that Dr. Quaye suffered disadvantage and discrimination by reason of his country of origin and race, though his father never knew of the protections afforded by S15 of the charter, and Mr. Quaye himself has only recently learned of them. While we understand Mr. Quaye's desire to illuminate Dr. Quaye's lived experience as a physician practicing medicine in the North so long ago, and to pursue restorative remedies, we confirm there is no legal recourse for any such wrongs available through the process Mr. Quaye has engaged and that have resulted in the appeal now fully heard before this court. 16. The application to admit new evidence is dismissed, as is the appeal. Appeal heard on April 29, 2021. Memorandum filed at Edmonton, Alberta this day of May, 2021. /1/GregelJ.A. Otho. 10. Filed May 10, 2021. RH. Page 5. Appearances. S.E. Heine for the respondent, Law Society of Alberta. A.M. Simmons for the respondent, Attorney General of Alberta. M.J. Redman A. Costigan, no appearance. L. Macklin, no appearance, for the respondent, College of Physicians and Surgeons of Alberta. Gerald Quaye the appellant, in person.